Welcome to the latest installment of House Bill 3 and 30. This one is on the new requirements for school administrators to report misconduct and the new Do Not Hire Registry of persons ineligible to work in Texas public schools. Today we're going to explain the how and why of House Bill 3. We'll walk through the new reporting requirements for House Bill 3, Senate Bill 1230, and Senate Bill 1476. We'll cover the Registry of Persons Ineligible to Work in Public Schools. We'll be calling that the Do Not Hire Registry for short. We'll talk about what it is and how it works, and we'll talk about what all this means for school districts. My name is Laura Moriarty. I am the Director of Enforcement for the State Board of Educator Certification.
And I am David Rodriguez, the Director of Educator Investigations. Let's begin by talking about why this matters. HB 3, Article 2A, was passed to further protect the safety and welfare of students. Ultimately, it does this in two ways. First, by requiring schools to report certain allegations against non-certified employees. And second, it requires the agency to build and maintain a database of individuals who are not eligible for hire in a Texas public school system based on certain misconduct or criminal history.
We'll start by discussing how and why HB 3 came about. Over the past 15 years, the legislature has made great strides toward addressing the issue of educators engaging in misconduct in one district, resigning, and then moving to another district just to do it again. In prior years, the legislature has addressed reporting requirements for administrators and has added fingerprinting requirements for people on campus. House Bill 3 continues that effort.
This chart represents the number of cases that the agency has opened on certified educator misconduct over the last 5 years. As you can see, there's been a large increase in the number of cases, approximately 65% since 2014. For the fiscal year 2019, the agency projects 1,450 cases will be opened by the end of the year. However, it should be noted the increase in cases is not necessarily an ominous trend. In fact, it could represent the fact that legislation previously mentioned has resulted in an increased reporting and overall increase in awareness on allegations of educator misconduct and the impact to students. By opening more cases year over year, the agency has the ability to investigate these matters and take necessary action to preserve the safe learning environment for students.
This slide shows the gap in authority prior to House Bill 3. It compares the authority that SBEC, the State Board for Educator Certification, had over certified educators and the lack of authority that anyone in government had over uncertified school employees. While the State Board for Educator Certification has authority to revoke and sanction certified people, it does not have authority over uncertified people, and an increasing percentage of school employees are uncertified. Districts of innovation and charter schools are exempt from teacher certification requirements. This slide shows the changes that the legislature made during this most recent session. House Bill 3 made public school administrators required to report for uncertified employees who engage in misconduct, and it created the Do Not Hire Registry, which is a registry of uncertified individuals that schools can't employ. Senate Bill 1476 allowed public school administrators not to have to report certified educators if the administrator has completed an investigation before the educator resigns or is terminated and determined that the educator did not engage in the alleged misconduct. And Senate Bill 1230 creates a requirement for private schools to report educators to the State Board for Educator Certification. This slide shows the gap that House Bill 3 filled. The SBEC still has authority to sanction certified educators, but now the Commissioner of Education has authority to put non-certified employees on this Do Not Hire Registry. So in summary, the new reporting requirements make public school administrators report non-certified employees who engage in misconduct. They create an exception that allows public school administrators not to report certified employees if the investigation is completed and finds no misconduct prior to the resignation or termination of the educator. And finally, it requires private schools to report educators to the State Board for Educator Certification for certain misconduct. This slide shows the reporting requirements for public school administrators, both for certified educators and non-certified employees. You'll notice that the areas for reporting misconduct for non-certified employees are much more narrow than they are for certified educators. It's essentially just abuse and inappropriate relationships with students or minors. Certified educators are subject to reporting for a variety of other misconduct. This slide shows the similarities between reporting certified and non-certified employees with regard to timelines and process. The timelines are exactly the same for certified and uncertified employees. You're going to be reporting within 7 business days, and the means for reporting are the same. House Bill 3 is going to require TEA to create a secure internet reporting portal by January 1st, 2020, but there are always the old-fashioned methods, mail and fax. We cannot receive reports via email. This slide shows what new reporting requirements mean to public school superintendents and directors. Senate Bill 1476 created an exception for certified educators. They don't have to be reported if the school completed an investigation and determined that the educator did no wrong before the educator resigns or is terminated. This carve-out does not apply to uncertified educators or employees. They still have to be reported regardless of the outcome of the investigation. And the penalties for not reporting are slightly different. If the superintendent who fails to report is an SBEC certified educator, then they are subject to SBEC sanction regardless of whether they failed to report a certified educator or a non-certified employee. However, they are only subject to administrative penalties, money damages, if they fail to report a certified educator. There is no such administrative penalty statute for non-certified employee failures to report. It is a criminal offense, however, either way, whether it's a certified educator or an uncertified employee that the superintendent has failed to report, it's a state jail felony. This is a summary of the private school reporting requirements. First, private schools under Senate Bill 1230 are only required to report educators if the person would be required to hold a certificate if they were working in a public school. And it's the chief administrative officer of the private school that is required to report. It's also limited areas of conduct compared to those for certified educators. It's essentially criminal conduct, abuse, and inappropriate relationships with a student or minor. Private school chief administrative officers are not required to complete an investigation, but have to turn over whatever they have at the time they report. The same methods of reporting apply. It's still mail, fax, or the new internet reporting portal. Again, no email, please. Where should schools send reports of misconduct? You've heard that we're sending them to both the Commissioner and the SBEC. That sounds like it's two different places, but in truth, both of those areas are supported by the TEA Division for Educators Investigations. So regardless of whether you need to report to the Commissioner or to the SBEC, regardless of whether it's a certified educator or an uncertified employee, you should send all reports to the Educator Investigations Division via mail, fax, or internet portal.
Let's discuss the Do Not Hire Registry. The agency will develop a registry of individuals who are unable to be hired to schools. The agency will also investigate allegations of misconduct against non-certified individuals and place those folks on registry. And then finally, schools must check the registry before hiring any individual and must terminate the employment of a person who is on the registry. Essentially, what is the Do Not Hire Registry? The registry is an online list of individuals who are not eligible for employment in a Texas public school based on misconduct or criminal history defined in the statute. There are three categories of persons who will not be able to be employed in a public school once they are placed on the registry. The first includes those individuals who were previously SBEC certificate holders but had their certificate revoked based on a finding that they either abused or solicited or engaged in a relationship with a student or minor. The second, and going forward, are non-certified employees found by the Commissioner to have engaged in similar conduct, which includes abuse or involvement in a romantic relationship or engaging in a sexual contact with a student or minor. And finally, the third category includes individuals who are found ineligible based on deferred adjudication or being convicted of certain crimes defined in the statute. This slide shows how TEA will receive and investigate reports of misconduct. The slide also shows the steps the agency will follow to provide an individual with due process and an administrative hearing. TEA will receive reports of misconduct through two ways. As previously mentioned in this presentation, the school will submit a report to the agency if an individual resigns or was terminated for certain misconduct. The Department of Public Safety will also notify TEA through the Criminal History Clearinghouse. Once a report is vetted, TEA will send the individual notice of the allegations and provide that person with the opportunity to 1. Request a hearing should the agency find the allegations are substantiated, and 2. Show cause as to why the agency should not list the individual as under investigation. If an individual can show cause, that person will be cleared for hire. TEA will remove the investigation status, and all record of the matter will be removed from the website. If the person does not show cause, the law requires TEA to list the person as under investigation on the agency's website. From this point, TEA will conduct the investigation. The investigation will gather facts and determine whether the allegations can be substantiated. If the allegations are not validated, TEA will remove the investigation status, and all record of the matter will be removed from the website. If the allegations are substantiated, but the person did not request a hearing, TEA will place the person on the Do Not Hire Registry. Additionally, TEA will contact the school that most recently employed this individual and inform them of the action. If a person requested a hearing, the matter will be heard in the State Office of Administrative Hearings. There are two possible outcomes to this step. If an administrative law judge recommends the agency does not sanction the individual, TEA will remove the investigation status, and all record of the matter will be removed from the website. However, if the hearing results in a ruling against the individual, TEA will place the person on the registry. Additionally, the agency will contact the school that most recently employed the person and inform the school of the action. There are several key events that must take place before the launch of the registry in early 2020. TEA has already begun the process of rulemaking. The agency has also started developing the registry and the reporting portal that was previously mentioned. By the beginning of the school year, the agency will have proposed rule changes under Administrative Code 153. On September 1st, 2019, schools must begin reporting the allegations against non-certified employees. Accordingly, TEA will begin investigating allegations against non-certified individuals. In October 2019, the agency will propose rule changes to Administrative Code 249. And in November, agency will continue its work on the registry development. This includes identifying all individuals who were previously certified but had those certificates revoked based on certain misconduct. Those individuals will be added to the registry prior to the launch in 2020. In December 2019, the agency will provide schools with technical information about how to access the registry, resources, and online materials, and what steps that they should take to make sure that they have the correct access. And then finally, in January 2020, schools will be given access to the registry. By February, the rulemaking process will be finalized. Technically, how will the registry work? To begin, school staff will access the TEA Secure application to check the registry. This is the application normally used for other functions such as fingerprinting. A user will upload identifiers, personal information of anyone being considered for employment or any current employee. The system will return a result to show that a person is under investigation or on the registry, or that there's no record found of them being tied to the registry. The check itself will be tied to the current fingerprinting process, and school staff who have access to the registry will also have access to the reporting portal. So what does this all mean for public schools? As mentioned before, effective September 1st, schools should create a procedure for investigating and reporting allegations of non-certified employees to the agency. Upon launch in 2020, schools must begin checking the registry before hiring potential employees. It should be noted that the agency will also do a check of the registry for all individuals who were loaded into the registry prior to that time. If any are found to be currently employed in a school district based on current employment records found in PEMS, the agency will notify the school district immediately. Then going forward, schools must terminate the employment of anyone on the registry, and the agency recommends that schools create a procedure for periodically checking all employees against the registry. Additionally, TEA will periodically review records to verify compliance, and non-compliance is a violation of charter or grounds for termination of a District of Innovation status. A question many may have is, will the public be able to see who is on the registry? Yes, there will be a public-facing page that shows who individuals are that are listed on the registry. However, due to privacy laws, the agency is unable to verify to the public by social security number or date of birth. The public will be able to see the name and the approximate age and the date an individual was placed on the registry. Should any member of the public need to know additional information, they may submit a public information request through the normal agency channels. Ultimately, the public-facing registry will be similar to the current virtual certificate lookup that the agency has for all teachers certified by the State Board for Educator Certification. That concludes our presentation. For more information about registry, reporting requirements, or HB3, please visit tea.texas.gov/HB3 or submit questions to the email listed on the screen.